Hello, I'm Fred Hopma, and this is the feedback for assignment Legal 1. I was happy to notice that many students put a lot of effort in making this assignment, and I'm also happy to notice that the grades actually are very good, so that is very promising for the other assignments. Okay, let's go to the case. This assignment started with a case, and the case says that in the Netherlands, between National Motorway A4 and Motorway A45, a new connection motorway will be built. Part of the new national motorway will be built as a drilled tunnel. Well, we can see the A4 motorway over here and the A44 motorway over there. And you can see in between, indeed, there is a motorway planned, and where the dots are, a drilled tunnel is planned. The first question is, requirements from EU law are equal for all EU member states. Which requirements of EU law apply to the decision-making for a new national motorway, such as the connection motorway between the A44 and A4? And question B is, give a short overview of the contents of the EU requirements. And this question was rewarded with 10 points, like every question. Okay, let's first go to 1A, the requirements of EU law that apply to the decision making. And these requirements are equal for all of the EU member states. So this comprises many countries on the continent. This is the correct answer. Although there are no specific directives for the planning procedures of new infrastructure, and thus we can see considerable differences between member states as for infrastructure planning procedures, all national procedures are quite heavily influenced by the EU environmental directives. So through the EU environmental directives, the national infrastructure planning procedures are influenced. Most relevant directives are, and here is an overview of 6 directives. The Environmental Impact Assessment Directives for project assessment, the Strategic Environmental Assessment Directive for plan and program assessment, the Birds Directive, the Habitats Directive, the Clean Air Directive, and the Water Framework Directive. Certainly for directives 1 through 5, it is very clear that they usually will have an influence, or perhaps even always will have an influence on the infrastructure planning. Well, each directive that is correct was given 1 point. However, the maximum number of points was 5 points. So even if you summed up 6 directives, the maximum number of points was 5. Let's go to B question. A short description of the contents of each of the directives so that you understand what each of the directives actually is about. Well, environmental assessment is a procedure that ensures that the environmental implications of decisions are taken into account before the decisions are made. So the governmental institutions need to be aware of the environmental aspects of their infrastructure decisions. Environmental assessment can be undertaken for individual projects, such as a dam, a motorway, airport, or factory, on the basis of the Environmental Impact Assessment Directive. But also for public plans or programs, the Strategic Environmental Assessment Directive. The common principle of both directives is to ensure that plans, programs and projects likely to have significant effects on the environment are made subject to an environmental assessment prior to their approval or authorization. So in this answer, you had to make a distinction between the 2 types of environmental assessment directives, one for projects and the other one for programs or plans. And of course, these large-scale programs and plans are the basis for later individual projects like motorways. The Birds Directive. Habitat loss and degradation are the most serious threats to the conservation of wild birds. The directive therefore places great emphasis on the protection of habitats for endangered and migratory species. It establishes a network of special protection areas, including all the most suitable territories for these species. Well, it was not necessary for you to mention the exact words as I have done, but you should give some contents of this directive and the other directives. Of course, there are many possibilities to describe the contents. The Habitats Directive ensures the conservation of a wide range of rare, threatened or endemic animal and plant species. Some 200 rare and characteristic habitat types are also targeted for conservation in their own right. Some students had the idea that the Birds Directive and the Habitats Directive are the same, but actually these are two different directives. The Clean Air Directive, well, it's obvious that it is of importance for new infrastructure projects like the A44 motorway. The Clean Air Directive ensures that existing targets regarding air quality are met. The packages also involve support measures to help member states to work towards these targets, improvements of air quality and cutting off pollutants. The Water Framework Directive. The goal of this directive is to ensure that the quality of surface water and groundwater in Europe meets high standards. The directive is based on a river basin district approach to make sure that neighboring member states assume jointly responsibility for managing the rivers and other bodies of water they share. So if a new motorway might influence some water bodies, this directive will be of interest. Well, this answer could be found on page 93 of the book Planning and Development Law in the Netherlands. For information about each of the directives, chapter 7 of the book gives a lot of information, and also there are numerous internet sources where short descriptions of the directives can be found. Each correct description, again, is 1 point. However, the maximum number of points is 5. Some students, again, mixed up the Bird Directive and the Habitats Directive, and some students did not give answer regarding the contents of some of the directives, and then some points were deducted. But in general, this question was answered very good. Question 2. A drill tunnel, as is the case in the connection motorway, is much more expensive than a motorway on ground level. Who, that is, which institution, takes the decision to construct a tunnel or a motorway on ground level? So who takes the decision to construct a tunnel or instead a motorway on ground level? 10 points for this question. Well, this question again was answered very well. The Minister of Infrastructure decides on the details of the infrastructure decision. This is through the track decision. And in chapter 6 of the books, the whole procedure of infrastructure planning is explained. And there it is explained that the track decision is a decision that actually lays down all the characteristics of the new infrastructure project. So is it on ground level, is the tunnel, the number of lanes, etc., etc. So it is the Minister of Infrastructure that takes the decision. 8 points if that answer was given. However, appeal against the minister's decision is possible for interested parties. So eventually, the administrative judge may have to test the minister's decision. So one could say that the minister's decision is tested by the court, and the court may nullify the minister's decision if it's in conflict with the law. So that addition is necessary and would be given 2 points. So if you did not include that in your answer, you would only lose 2 points. This is explained on page 100 of the book Planning and Development Law in the Netherlands. There was some were some alternative answers to question 2, and these alternative answers also are given points. Some students said the Ministry of Infrastructure instead of Minister of Infrastructure. That is -1 point. Some simply said minister, so without indicating which minister. That would lead to a deduction of 2 points. Some students would say Rijkswaterstaat. That was given 2 points because Rijkswaterstaat actually only is one of the organizations within the Ministry of Infrastructure. Some students said it was the second chamber of parliament. The second chamber of parliament is involved, but only as a reactive institution, reacting to the track decision of the minister, 2 points. And some students gave an explanation of the 3 domains of power, but without acknowledging that the minister has the power to initiate procedures and has a central position. That would be given 3 points. Question number 3. Drill tunnels are technically complex products. The structural requirements for tunnels are laid down in a document which has a legally binding status. What is the name of this document? Again, 10 points. So what is the document that specifies all the technical details for tunnels? The name of the document is Building Decree or Building Code. And that is explained on page 41 of the book. Any country has a document holding the technical specifications for buildings and infrastructure projects. In English, we call it Building Decree or Building Code. In Dutch, it will be Bouwbesluit. Usually, the documents hold numerous technical specifications for buildings and infrastructure works. For instance, for buildings, it relates to structural requirements, fire regulations, daylight entrance, minimum surfaces, minimum heights between floors and ceilings, slope of stairs, etc., etc. I was happy to see that almost every student answered this question. There were some alternative answers to question 3. A few students said Eurocodes for tunneling. Well, this was given 2 points because the building decree refers for calculations to documents like the Eurocodes, but the structural requirements themselves are laid down in the building decree. Some students refer to the safety norms for road tunnels. They are mentioned in the book on page 39. And well, my comment is that these safety norms cover only part of the technical requirements for tunnels. The actual structural requirements that was asked for are laid down in the building decree. And page 39 of the book shows clearly that the safety norms exist besides the regulations of the building decree. Let's go to question 4. Suppose that for some parts of the new motorway, landowners need to be expropriated by national government. What can be said about the height of the compensation the landowners receive in case of expropriation? 10 points again. So what about the amount of money that will be given to the landowners in case of expropriation for a motorway? This is the answer. The landowner in case of expropriation has a right to complete compensation. The compensation is either based on the value of his land and buildings erected on it under the current use. Well, from question 4, it's unknown what the current use is. Or the value of the land and buildings taken into account the future use, which in this case is motorway, depending on which of the two is the highest. Page 26 and 27 of the book, Planning and Development Law in the Netherlands, explains this. So, what is of interest is the function of the land under the new land use plan for which is expropriated. In this case, it will be motorway. So there is a comparison between the current use value and the value of the land as land for motorway, and then it is decided which one is the highest. So this is what can be said about the height of the compensation. First, complete compensation. Second, there's a comparison between the current use and the future use. And then the highest one will be compensated. So if the current use is agricultural land and the future use under the land use plan is residential, and expropriation takes place for residential purposes, in that case, the value of residential area will be compensated, which is much higher than for agricultural land. In case of a motorway, we're not sure if it's higher as the current use, but this is the formula. Some students said simply complete compensation, or gave an extensive explanation what complete compensation entails without mentioning the term complete compensation. That was given 4 points. So in that answer, the comparison between the actual value and the future value was missing. If students said value of current use or future use, depending which is the highest, is 6 points, because then also part of the complete answer is missing, because the complete compensation was not elaborated in that very short answer. And that was necessary as well. The court will determine the height of the compensation. That is true, but it misses some of the elements of the correct answer and therefore will be given 4 points. The height of the compensation is determined by a third party. That is correct in itself, but will only be given 2 points because it's not really specific. The basis is the market value, but without explaining that there will be a comparison of the value under current use and future use and that the highest will be compensated, was also rewarded 4 points. So some of the variations and answers also were given points. Final question is number 5. How would you describe the planning procedure for a new national infrastructure in the Netherlands? That is it hierarchic, or is it based on finding a solution which is acceptable for all public and civic parties involved, or something else? 10 points for this question. I would say that the planning procedure for new national infrastructure in the Netherlands can best be described as relatively hierarchic. It's hierarchic in the sense that the Minister of Infrastructure takes the track decision, and the Minister does not need the consent of other actors or institutions. However, it's relative hierarchic and not absolute hierarchic, because prior to the minister's decision, a lot of consultation takes place between the minister's civil servants and others, like municipalities, special interest groups, and so forth. All these parties have the right to be consulted and can submit views relating to draft decisions of the minister. Also, there is the domain of politics. The minister is controlled by legislators in parliament. So in effect, there are 3 domains of power: administration, politics, and justice. However, in the end, the minister decides. After the minister's track decision has been taken, interested parties can lodge appeal with the administrative judge. But that does not take away that the minister takes the track decision. And the track decision has binding effect towards local land use plans. That is hierarchic. Well, on a personal note, now that we are dealing with national infrastructure and not municipal or regional infrastructure, it is perhaps understandable that the minister has the important power to take the track decision. See Planning and Development Law in the Netherlands, pages 100, 102, and 103. Well, this question had a large variety of answers, understandable, and each answer was judged on its own merits. However, here you can find an overview of elements of the answer that were given specific points. The planning procedure is based on 3 domains of power, and saying not one domain is dominant was given 6 points. Quite some students answered this referring to the 3 domains of power, but as we have just seen, a little bit more explanation had to be given. A solution which is acceptable for individual but protects the general interest is given 5 points. In itself, it is correct, but the correct answer needed a little bit more explanation. It is mostly hierarchic, and an explanation would be given 6 points. And if students were given only an overview of the planning procedure for new infrastructure without comments on hierarchy, and some students did that, that was given 0 points because you had to elaborate on the hierarchic character of the procedure and not simply copy the procedure from the book. It is hierarchic because the administration comes up with a decision and policy decides whether or not to accept this, would be given 2 points because that is a little bit too, well, a little bit is quite too short and not deep enough. Much more can be said, as was demonstrated in the previous slide. Okay, these were the questions, the correct answers, and the alternative answers that were given points. In general, again, compliments for you because the assignment was made very well.